Hey everybody, welcome back. Today we're talking about Chapter 2, the Constitution. We're going to be really breaking this down, seeing what the Constitution really brings to the United States experience, to the governmental experience, what it is, and how it works. So, like I said in the first chapter, make sure that you are paying attention to all these terms, writing them down, making them on your notes list is going to be really helpful as you go through. So, the first thing that I want to talk about is the question of what the Constitution actually is. A Constitution is basically presents the mission statement of the United States government, the fundamental principles, the foundational structure, the ability to, or kind of the idea of what the structure is. So, in the very beginning of the Constitution of the United States, you have the preamble to the Constitution, and it breaks it all down. We, the people of the United States, in order to, and then these are the 6 goals: form a more perfect union, create a union that we already have, and make it more perfect. Try to continue improving it. Establish justice, the idea of law and order. Ensure domestic tranquility, to allow the people to live their lives and without fear of intervention. Provide for the common defense, secure our borders. We talked about this in the last lecture. Promote the general welfare. Now, that one's really interesting because that one is one that people will point back to when they talk about the different social services that are implemented in the United States. And then secure the blessing of liberty to ourselves and our posterity. We talked about liberty before, how it's really important in the U.S. system. And liberty is the freedom from government control, not only for ourselves, as it says here, but also for our children, for our posterity. Do ordain and establish this Constitution for the United States of America. This idea that the Constitution was created as the roadmap as we go through the mission statement. Now, it's important to identify how we got to where we are and where we came from in the beginning. Now, in the case of the United States, if you've taken an American history course, American History to 1865, you've probably discussed colonialism, the idea of the English colonists coming from England, France, Spain, the Netherlands, into the Americas in the 1500s or so. And colonialism was a major part of many European powers in the 15 to 1700s. Now, in the United States, in the case of the United States, or what is now the United States, North America was largely dominated by English colonialism. Yes, there were parts of Spanish colonialism in Central America and Florida, and on the west coast of the United States, French colonialism in the central part of the United States and in Canada, but a majority of the colonialism on the eastern seaboard was English. And these are the colonies that were very largely developed during the 1700s. Jamestown was established in the early 1600s. This was the first permanent settlement by the English in North America. There were earlier settlements that were established, but the first permanent established settlement was Jamestown. And there were really 5 major sectors of early colonial politics. And these were kind of broken apart into the New England merchants. New England was basically these northeastern areas where we have New York, Pennsylvania, New Jersey, places like that, where a lot of the economic activity was focused on merchant activity. And then you had the southern planters in places like Georgia, South Carolina, Virginia, in which they initially were growing tobacco crops. Royalists, who were the large landholders who had land that was granted to them by the monarch, by the King of England, and then shopkeepers. These were kind of the small business owners of the colonies. Generally, if you were a shopkeeper, you had some amount of wealth, and then the small farmers who were operating in most cases, the South, places like Virginia, North Carolina, South Carolina, and Georgia. They were operating in many parts landowners who had these established farms as well. Now, when we talk about what led to the Declaration of Independence and then into the establishment of the United States, it's important to track a couple of different key touch points of in colonial history. First, we have Bacon's Rebellion. So 1675, you had Nathaniel Bacon, who was kind of this backwater elite of the colony and wanted to expand westward. Basically, there wasn't enough territory on the kind of the eastern seaboard, so these backwater groups were trying to expand westward, but the people in the west were the Native Americans. And so as these English colonists are expanding westward, they're encountering friction and pushback from the Native American groups that had already been removed from the eastern seaboard. And so Bacon's Rebellion was basically an establishment of a militia, an unlicensed militia essentially, and then they were expanding west on their own. When Governor Berkeley is basically chastises Bacon for expanding west, Bacon turns and marches on Governor Berkeley. And so what you have in 1675 is this expansion westward, and you have England stepping in and basically saying that the United States or the colonies are not able to expand westward outside of English allowance. So what this is England basically saying your ability to expand in this new territory is constrained by the crown. You can't make those decisions on your own. You can't make those decisions within the colonies. You also have, in 1760, George III ascending to the English throne after a war with France. And he sought to reassert colonial authority over the colonies. And they did that with the Proclamation of 1763. Like I said, that limits the expansion westward. You also had George III and his Prime Minister, George Grenville, see the colonies as kind of this opportunity and way to pay off war debts. After 1760, after a war with France, George III is basically like, let's use the ability or these colonies to pay off that war debt. And so they implement the Sugar Act of 1764, which restricted the colonial sugar trade. Now, this came on the heels of the Molasses Act, which restricted cheap island or Caribbean molasses that was being used to make rum, that was being imported into Europe. After a restriction on that expands to the restriction in the Sugar Act of 1764, which restricted the colonial sugar trade and essentially was an effort to raise funds for the crown. This was seen as another action by England to restrict the ability and freedom of economy within the colonies. This is expanded in the Stamp Act of 1765, and this taxed essentially everything made of paper, so letters and envelopes and newspapers and things like that. The Stamp Act was really important because up to this point, there were a lot of revenue-raising acts implemented by England, forced onto the colonies before the Stamp Act. But the Stamp Act was really important because the Stamp Act limited or what had an economic impact on everybody in the colony. So anybody that was buying paper was affected by the Stamp Act. And this led to the rise of the popular phrase, no taxation without representation. The idea was that in the British Parliament, that the colonies didn't have representatives. And it was got to the point where you had parliamentarians arguing that, oh, well, yes, you're represented through virtual representation. Basically, every member of parliament speaks for everybody in the kingdom. So even though you don't elect a member of parliament, you have one speaking on your behalf because all of them are speaking on your behalf. Well, the colonists are seeing that and they're saying, well, that's a bunch of bull because I didn't elect that person. Of course, they're not going to take my interests to heart. They are going to be focusing on enriching England. So you had representation, real and virtual representation, really being discussed there. And this kind of comes back to what we're going to be talking about later when it talks to the House of Representatives, how the House of Representatives, the individual representatives are elected from a specific locality. And even though you might see a specific representative as representing your affiliated political party, they're not representing you necessarily, they're representing a specific locality. So if you live in Oklahoma, you might have a specific representative. Your representative might be different from the representative from California. So, or is going to be different from the representative from California. Even though they collect together and work as a team and all that sort of different thing. This all kind of comes to a head in 1770, in March 5th of 1770, when at Boston there is a protest to taxation, and there is a group called the Liberty Boys who are protesting taxation. They come face to face with British regulars. The exact nature of the Boston Massacre is not exactly known, but we know at some point there was probably rock throwing and snowball throwing, and at least at some point, one or several of the British soldiers opened fire, and 5 colonists were killed. Now, it is really important to recognize that public spin is nothing new. Paul Revere of the Midnight Ride fame actually circulated an engraving of the incidents of Boston, in which he titles it the Boston Massacre, labels that image, and demonstrates what he sees as this violent massacre of malicious British regulars against innocent colonists. Well, this is the spin of the story that took hold around the colonies and ignited this kind of revolutionary passion. It certainly, the revolutionary ideology was present before this point, but this had a major influence in increasing revolutionary sentiment. You also had the Boston Tea Party following the Tea Act. The Tea Act reduced the price of tea, but it instituted a monopoly in which the East India Company was the only producer that was able to distribute tea to the colonies. So you had the Boston Tea Party, in which individuals dressed up as natives went onto the ships, dumped the tea into the harbor, the Boston Tea Party. And England responds to this with the Coercive Acts, or the Intolerable Acts. Coercive Acts are what they were called in England. The Intolerable Acts are what they were called in the colonies. The Intolerable Acts were essentially implementing military law in Boston, closing the port in Boston until that is repaid. Basically, all of these punitive measures that were taken against Boston and Massachusetts in response to the Boston Tea Party. So by 1774, you have the First Continental Congress, and this is basically a group of individuals all gathering together to address grievances. And when I talk about Congress, in this case, it's just the act of coming together, the action of taking individuals, bringing them together, and addressing these grievances. And they decided that, okay, we're going to petition the government, or we're going to petition England, and then if they do or don't respond, we're going to set another Continental Congress for 1775. And we're going to pick up these issues again. Well, the king doesn't respond. In 1775, the Second Continental Congress comes together. But while the Second Continental Congress is taking place, you had the battles at Lexington and Concord, in which the British troops marched down to Lexington and Concord in order to eliminate or destroy powder and ammunition stores that the revolutionaries were keeping. And during this, you had skirmishes between the British regulars and revolutionaries. During the Second Continental Congress, you had what was called the Olive Branch Petition. The Olive Branch Petition was basically a document that was sent to England saying, hey, listen, this is what we want to be. We want to be our own independent thing under the authority of the crown, but we will kind of dictate our own affairs, but be subject to England. This is kind of the way that like Australia and Canada still operate. They operate much more independently than this agreement would have arranged. But this agreement was a potential way to say, look, we're fine with being English still, but we want to dictate our own affairs. We want to have control over our own affairs. George III rejected this petition because, in his eyes, he's saying, "Of course, I'm not going to release any control. I am the king. I have the military. I have absolute authority." So he rejects this petition and closes off all international trade to the colonies. And this essentially leads to the Declaration of Independence. And the colonies say, fine, if we're not going to be able to be part of the English crown, what we're going to do is we are going to declare our independence from the English. And this included the assertion of the rights of life, liberty, and the pursuit of happiness. And in addition, this was an important mechanism in order to unify the colonies as a singular entity. So the Declaration of Independence was necessary because it was necessary if the colonies were going to basically free themselves from England. They had to come together in order to act in a coordinated way. So initially, the idea is, okay, well, we've got this system in place. We are now independent. What are we going to do with it? And so what you have is the establishment of the Articles of Confederation and Perpetual Union between the states. And the Articles of Confederation and Perpetual Union is more commonly just called the Articles of Confederation. This was a loose agreement that allowed the states to operate independently in almost all cases, but as a unit in others. This allowed for the establishment of a continental military, a continental army. And this was a unicameral system, unicameral meaning single house, uni meaning one, cameral meaning house, a single house system where all states had a single vote in national matters. They could send a variety of delegates, but they only had a single vote. Today in the United States, we have a bicameral system, a two-house system made up of the Senate and the House of Representatives, and that makes up our Congress. The Articles of Confederation was this first founding document where all 13 states had to agree to any changes. This allowed Congress to declare war, make treaties, borrow money, regulate trade, but the armed forces were comprised of state militias that were coordinated together. There was not a single president. There was one who presided over the Congress, but there wasn't a president, no executive, and the delegates were paid by their individual states. Now, we know that due to the fact that we have a constitution, the Articles of Confederation must have been eliminated at some point, and the question becomes, why? Well, within a few years, it becomes clear that the Articles are insufficient. There was no national military. The United States couldn't enforce its treaty, any of its treaties. Some of the states were kind of controlled politically by small landholders and shopkeepers rather than the traditional elite. And this was a significant problem. It was a problem because states had significant power to manipulate their currency, whether through implementation of land redistribution, and make economic systems that were one-sided. So if Georgia wanted to interact with New York, the two systems could be vastly different, and they could be operating off of a different set of economic principles, and one could take advantage of the other. And so even though all the states operated individually, there wasn't a way to really regulate state-to-state commerce or a nationalized military system, things like that. However, what you did have was a system for acquiring land and adding new states. So fairly early on in the U.S. history, you have the acquisition of the Northwest Territory, the Ohio Territory. And so what you have is this large piece of territory that the government owns, and they formed the Ohio Company to basically sell off this land and use that money to create a national road, basically a road that would connect the eastern seaboard to the interior. And the Northwest Territory was organized under the Articles of Confederation and populated during this time as well. Now, following the Revolutionary War, you had a system where the national government is trying to pay off its debts. As it tries to pay off its debts, it raises the taxes. This is very similar. This is very similar to what happened with England prior to the Revolution. They were trying to raise these taxes in order to pay off the debts. The U.S. federal government's trying to do the same thing. And what happened is poor farmers were disproportionately affected. Poor farmers were landowners, but they might have been in debt. They might not have had enough money. They might not have had enough product to be able to make the farm successful. So in many cases, you have these Revolutionary War veterans who are low-level farmers who are having to pay these taxes because they are landowners and they are losing their property. At the same time, if you are unable to pay your debts or things like that, you could be thrown in prison. And we'll talk about that a little bit later. So Daniel Shays is a Revolutionary War captain, and he forms a militia, and this is called Shays Rebellion. Daniel Shays demanded paper money. Paper money is really important because if you have hard currency like gold or silver or whatever, it can be transferable and spendable, but it's not easily subdivided. So if you have $100 worth of gold, you can't shave off a little bit of that and then use that as $10 worth of gold. You could technically, but not everybody's going to accept it because then they have all of these tiny shavings of gold. So what they want is paper money, in which they're able to take these paper money systems and exchange in lower denominations and have some liquidity where people can spend and receive money. They wanted tax relief. They wanted a moratorium on debt, basically a pause on debt, because in this new system you have a debt structure and a monetary system that is in a brief recession, because most generally post-war you'll have a recession as reconversion takes place, and then an end to debtors' prison. And it was Shays' Rebellion specifically that rattled George Washington to the point where he signed on to a constitutional convention. He said, "I am mortified beyond expression that in the moment of independence we should render ourselves ridiculous in the eyes of Europe." Basically saying that we have gained our independence, but we look like fools because we can't take care of our own people. The whole point of this was to take care of our own people, and we're not able to do that at this point. Something needs to change. So what happens is, in May of 1787, 55 delegates from 12 states come, and the initial goal is to revise the Articles of Confederation. They're saying, okay, the Articles of Confederation is fine, but we need to improve it a little bit, so let's come back to this. Now, 70 were initially chosen, but 55 delegates attended. Rhode Island did not attend because in the initial discussions, Rhode Island was a small state and feared excessive government power. And so, as a small state fearing excessive government power, they just don't send anybody to this. 39 eventually signed the Constitution as it was written. Now, when we talk about the Constitutional Convention, it's really important to highlight the Constitutional Convention demographics. We talked about demographics in our Chapter 1 lecture. It's really important to highlight these things because just because an individual falls into a specific demographic category means little, but it does mean something. It does mean that the attitudes that they're going to be bringing to this environment are going to be completely different. So it goes without saying, women and people of color were not in the Constitutional Convention. All of these individuals were white. At least 95% of them were some form of Trinitarian Christian. When I talk about Trinitarian Christian, I talk about a Christian faith of Father, Son, Holy Spirit. Now, not all of them were in this group. Some were deists. Deists were kind of this a group of individuals who viewed God, the idea of God as a watchmaker, an individual or a being that created everything and set it in motion, but does not interact with the daily lives of individuals. Now, so at least 25 or at least 95% of those individuals were Trinitarian Christians. It's also important to notice that all of these individuals were elites, and all of these individuals had a very specific set of, or very specific type of occupation. So over half were lawyers. 75% were either lawyers or merchants. Another large group were politicians. There was a single teacher, there were two teachers, two doctors, one farmer. Benjamin Franklin was identified as an inventor. So most of the people that are engaged in this process are lawyers and merchants. So the people that they are going to focus on are going to be lawyers and merchants. That's not going to say that they're intentionally making this system and intentionally making this document in order to unfairly bias themselves, but they're coming in with a specific worldview from the viewpoint of a lawyer and a merchant. So you have that type of attitude that's being brought in. And this is all to say, not to say that it was stronger or weaker because of any certain demographic thing, but it is important to recognize that there were demographic oversights and demographic disparities in the creation of the Constitution. Now, when we're talking about the Constitution, we're going to talk about this later, there is an amendment process. And through this amendment process, we have, as a country, expanded the constitutional protections to individuals, whether they are Hispanic or African American or women or things like that. We've expanded a lot of those protections to those individuals, but at its very face, at its creation, it was a document that was primarily focusing on the issues of a specific group of elite individuals. So yes, they were taking those things into consideration, but we have to be able to recognize the demographic historiography that this was created in. Now, in terms of structure of the government, we had two systems that were promoted at the early part of the Constitutional Convention. And this was the Virginia Plan and the New Jersey Plan. The Virginia Plan was the idea of, okay, let's have a single house, and we're going to have representation based on population. So basically, the more people you have, the more representatives you have in national affairs. Well, obviously, big states like Virginia are going to like that because they have a lot of people. And they're going to say, okay, we have a lot of people, we have a lot of say in how things go. On the other side of that, you have the New Jersey Plan. The New Jersey Plan says, no, I think we should keep it closer to the Articles of Confederation. Excuse me, Articles of Confederation, where we have a single set of equal representation for every single state, so that every single state gets a say. Now, obviously, the smaller states are going to like this because everybody gets a fair shot, but the larger states are going to say, well, we have more people, and they have the ability to be dominated by smaller states. So what you have in response to this is the Connecticut Compromise, or the Great Compromise. The Great Compromise created two houses. It basically said, we're going to have a House of Representatives that is based on population. The more people you have, the more seats you have. We see that today. The largest number of seats are in Texas and California. You have a smaller number of seats in places like Wyoming and Dakota, North Dakota. So you have this Connecticut Compromise where you have the House of Representatives based on population. You also have a Senate that has all states having two senators. So it's basically taking the Virginia Plan, taking the New Jersey Plan, smashing them together. And in that way, you're able to have input from both population-based and equal representation. And what we've seen, and one thing that was discussed in early America, was the House of Representatives as being closer to the population, closer to the will of the people, and the Senate being what was called the cooling saucer of the House of Representatives. So you'd have all of this legislation come through the House of Representatives. Once it came to the Senate, they could analyze it with a more critical eye. You also had the implementation of the 3/5 compromise. So the 3/5 compromise was focused on how enslaved individuals were going to be calculated based on population or property. Well, obviously, the slave states wanted their slave population to be counted as individuals in terms of representation, but they didn't want them to be counted as property in terms of taxation. The non-slave states wanted the opposite. So what they had is they came up with is basically the 3/5 compromise. The 3/5 compromise was basically an agreement that slaves would count as 3/5 of a person when counting population, and that they'd also be counted as 3/5 when focused on taxation. Now, this is one of the situations in which it's important to recognize the demographics of this situation, this constitutional convention, because you have a system that is inherently put in place that does not recognize the humanity of an entire population of individuals, and recognizes them not only in terms of part human, but also as property. And so when we talk about this discussion, this is already forefront at the minds of at the Constitutional Convention. But it is something that we have to recognize. It's something that we should not ignore, that when it comes to the issue of slavery, you have these individuals who are focusing on this from a very specific worldview, a very specific lens. Even if they didn't necessarily agree with the institution of slavery, they're focusing on these individuals, recognizing in one way, recognizing them as people, as individuals, but in another way, recognizing them as less than individuals. So it's something that we need to take into consideration as we focus on this. Now, the Constitution itself is broken into a couple of different pieces. You have your preamble, which is your statement of purpose; your first section, which establishes legislative branch; the second section, which establishes the executive branch; third section establishes the judiciary; the fourth section establishes the rights of the states; the fifth establishes the process for amending the Constitution itself; the sixth, establishing the Constitution as the supreme law of the land; and the seventh, establishing rules for the ratification of the Constitution itself. The meat of the Constitution is in section 1, 2, and 3. Breaks apart all the different federal processes. This establishes checks and balances and a separation of powers. This is really important and forefront on the minds. One of the things that you have to focus on when talking about the Constitutional Convention is the worldview that they're coming in from. I've talked about this before, but in terms of their interaction with England, what are the faults that they saw in the English system, and how are they trying to address that? One of the main faults in the English system is that the Constitution was not a written document. It was a collection of all the legal history, all the laws passed by Parliament and through the king and all that sort of thing collected together, but it was not a single established document with a set of governing rules. In the case of the Constitution, the intent was to add what were called checks and balances to this system. That one branch of government was not going to be able to overtake another piece of government. So you have this system of checks and balances. We'll talk about this a little bit more in later lectures as we break apart each of these branches. But it's important to know that in the United States system, we have three systems. We have the executive branch, which is the presidency; the legislative branch, which is the Congress made up of the House of Representatives and the Senate; and then the judicial branch, which is the collection of courts in the United States. Now, let's start with the legislative branch. The legislative branch was the most important to the Constitutional Convention. They see this as the group of individuals, and the group of individuals were the most important. You had a bicameral system, which is made up of two houses, and the first is the House of Representatives. The House of Representatives was the lower house, it has 435 members, based on population, and it is designed to be highly responsive to the public. You have 2-year terms. So basically, an individual goes in. If they reflect the will of the people, they will stay in. If they don't reflect the will of the people, they will be replaced by somebody who will more accurately reflect the will of the people. The House of Representatives is meant to be highly responsive to the whims of the American public. The Senate, on the other hand, was the upper house, currently set with 100 individuals. It's 2 per state. If you were to add 2 more states, you'd have 104 members in the Senate instead of 100 members in the Senate. But it was established to protect against excessive democracy. This is one of the major things that the constitutional members of the Constitutional Convention were focused on. The idea of excessive democracy. We want to have democracy, but the will of the people can be rapidly changing, and we don't want to have a system in which the majority is always rapidly whiplashing the country from one place to another. They wanted to have a system that was set in place to establish and maintain a status quo. Because one of the main goals of the federal government in the United States is to establish reliability, a evenness, a level system. Because if the less surprise or change that can occur very rapidly in the United States, the more stable the system is, and the more stable the economic system is, and the more stable everything else is. So introducing rapid monumental change is generally unlikely in a governmental system that is focused on stability. The powers of the legislative branch were to collect taxes, borrow money, regulate commerce between the states, declare wars, and maintain the military. Now, these are the expressed powers of the legislative branch. The expressed powers are the powers that were listed in the Constitution only belonging to Congress. Now, in addition to express powers, there was the elastic clause, or often called the necessary and proper clause, in which the legislative branch was able to create all the laws necessary and proper to carry out its expressed powers. So, the elastic clause allows Congress to write different laws that allows it leeway in carrying out its powers. So, it has the power to collect taxes. It has the ability to write laws to establish the IRS to collect taxes. And then through the bureaucratic process, the IRS can establish certain dates and restrictions in which taxes have to be collected and how they should be collected. The legislative branch writes the tax code, but it has basically given the actual collection process to the IRS, which operates under the legislative branch or the executive branch. We'll talk about that a little bit later. The executive branch was established in order to be a timely reactive office. Now, framers feared executive authority and the potential of a monarch, but they wanted to have somebody who could react in a timely manner. So communication in the 1770s, 1780s, 1790s was very slow. It was very difficult to communicate from one part of the nation to another important information. Most of the time, you're having to do so through a mail system of horseback, or boat if you're lucky. So the ability to communicate between individuals was very, very slow. And so the framers wanted to have a system, an office set in place where they had the ability to react in a timely way that didn't require the collection of all the entire Congress, bringing them all together, presenting the information, and then making a decision and then implementing that decision. So you have the executive branch. Now, the Electoral College, we'll talk about the Electoral College in a little bit, but the Electoral College was implemented as a way to account for this information flow. The Electoral College was implemented as a way to, if new information or if important information came to light between the election of the states and the nomination of the president, that information would be able to be taken into account in the selection of the president. Now, like I said, we'll talk about that later. In the case of the president, you had 4-year term limits. Now, there was no limit in the Constitution to the amount of terms that an individual could spend in the presidency, but it was then limited in the 22nd Amendment following Franklin D. Roosevelt being elected to his, I believe it was 4th term, and then dying in office. So you had these systems in place that were initially, it was, okay, you're elected to 4 years. If you do a good job, you could be elected into perpetuity. But following the 22nd Amendment, as a nation, we decided maybe you shouldn't have the unlimited ability to serve for life. That leads to the possibility of a dictator. You had the express power to negotiate treaties and conduct foreign affairs. Now, this is where the executive office is so powerful. We'll talk about this when we talk about the presidency. But one thing the framers did not account for, or one oversight that the framers had, is they gave the executive broad authority in national affair or international affairs. Now, in a globe that has become so small, international affairs dominates most of the political situation right now. And so the presidency itself, the office of the presidency, has a massive ability to affect not only national but international policy because of their ability to engage in international policy. So you have the negotiation of treaties and the conduct of foreign affairs. You have the appointment of personnel, the granting of pardons, the convening of Congress, the right to veto legislation, and the ability to react in a timely way. It was also the responsibility of the executive branch to execute the laws that were passed by the legislature. So the legislature writes the laws, puts them into effect, and it's the responsibility of the executive branch to carry out those laws and make sure those laws are implemented. You also have the judicial branch. Now, the court system's kind of like a pyramid. It doesn't really look like a pyramid here, but the court system is like a pyramid because you have the Supreme Court at the top, and then you have a state path to the Supreme Court and a federal path to the Supreme Court. Now, the Supreme Court was initially established to resolve conflicts between the states. If New England or New Jersey had an issue with Virginia, they could take it to the Supreme Court. The Supreme Court would judiciate or basically go in and say, this is, Virginia is right in this case or whatever. They had the power to resolve conflicts also between the federal government and the states. Now, one of the things that was implemented in the Constitution was the justices of the Supreme Court would serve lifetime appointments. This was established to remove them from basically political influence. The idea is that a justice will be appointed, and then during their tenure, there will be several presidents that come and go, or several Congresses that come and go while they are serving, so they should be free from political pressure. They cannot be removed except for major, in the case of major misconduct. And so they have that there. Now, judicial review, the process where the Supreme Court can declare a law as constitutional or unconstitutional, was not implemented until 1803 in Marbury v. Madison. William Marbury was an individual who was appointed to a federal judgeship under John Adams. John Adams, who had served a single term, had just been voted out of office. He writes up a bunch of these midnight appointments, is what they're called. He basically appoints a lot of judges in his last few days in office and then appoints them to their seats. One of those individuals was William Marbury. His letter was written but was not sent out. Thomas Jefferson comes in, and his Secretary of State, James Madison, finds the letter and says, "What do you want me to do with it?" And Thomas Jefferson says, "Don't deliver that letter. We're just going to pretend it doesn't exist." And William Marbury knew he was supposed to get the letter, goes to the Supreme Court, says, James Madison should deliver this letter. It was written to me. I am owed this letter. Now, the really important thing happens here is John Jay basically says, okay, the Judiciary Act of 1790 is basically gave us the ability to force and compel an individual to do something. Well, the Supreme Court says in passing that act, that was not an expressed power of the judiciary. So the judiciary doesn't have the ability to compel an individual to do something. So what they say is William Marbury has a right to his judgeship. He has a right to that letter. However, the Supreme Court cannot compel James Madison to deliver that letter. And so, because the Judiciary Act of 1790, as written by Congress, was not constitutional, it was not a right that the legislature had to give. So, by finding that they have limited powers, less powers than the legislature gave them, the Supreme Court essentially gave itself the right to declare a law as unconstitutional. The ruling in Marbury v. Madison didn't really have anything to do with the case of Marbury v. Madison, because they say we're not able to do anything in the first place. We can't compel James Madison to deliver this letter because this law was unconstitutional as it was written, which implemented the process of judicial review, which gives the Supreme Court the power to interpret the Constitution, in which a vast majority of the cases that go in front of the Supreme Court are now focused on, finding and deciding on the constitutionality of these cases. Now, you also have the idea of national unity. I talked about this before. The Supremacy Clause in Article 6 established the Constitution as the supreme law of the land. The laws of the states will be in effect, but the absolute ground level base law of the land is the Constitution. You cannot make laws that don't at least meet the level of the Constitution. You can make laws that that kind of go beyond the Constitution, but they cannot degrade or undercut the Constitution. All federal, state, and local officials swear loyalty to the Constitution. More than the state constitutions or state laws, they swear absolute loyalty to the Constitution. All federal laws should be viewed as state laws. Now, there are gray areas when it comes to things like marijuana policy and things like that, but for the most part, all federal laws should be viewed as state laws. And the Constitution could be amended with enough support and would take effect if 9 of the 13 states agreed to ratify the Constitution. Now, let's go to ratification. Ratification is the process of agreeing for this to take place. Ratification is the action of giving formal consent to an agreement to make it valid. Now, the Constitution had to be approved by each state, 9 of the 13 states, but it was particularly difficult in the case of the Articles of Confederation. Every state had to agree. Now, you're going to have certain situations in which some states, maybe 1 or 2 states, don't agree. And so the ratification of the Constitution had to go through this ratification process, and it was fairly difficult because there were these systems in which some individuals wanted to have a system in which the Constitution was the operating document, but some states or some individuals liked the Articles of Confederation. There were good things within the Articles of Confederation. And so this process of ratification was fairly difficult and led to the rise of Federalists and Anti-Federalists. Federalists were the individuals who supported the idea of a centralized government. They liked the idea of a central system, and in that system, you had government through federalism. We'll talk about federalism in chapter 3, but federalism is basically the idea that there are different levels and that implement what's called filtration. Filtration protects against excessive democracy. Filtration basically means that in order for something to reach the level of national importance, it has to go through all of these different levels of government. In order to reach the level of the Supreme Court, you either have to go through the federal court system or through the state court system up through this appeals process. In order to reach the level of national policy, you have to go through the House of Representatives and then to the Senate and then to the president, and then if the president vetoes it, back to the legislature, and then they have to support it by an even larger margin. So this idea of filtration was implemented in a way to protect against excessive democracy and the unbridled will of democracy and the unbridled will of the people. Because as we've seen, the will of the people can change very rapidly. You look at air travel, attitudes toward air travel in 1999 and the attitude towards air travel in 2002, and those are very different. And the will of the people and the attitudes of the people changed very quickly following those, basically the term of one senator. So the Federalists primarily consisted of the individuals, the elites who wrote this Constitution itself. Now, on the opposite side, there were the Anti-Federalists. The Anti-Federalists supported this more decentralized view of government. They liked the idea of state supremacy with limited interaction from the federal government. They feared concentrated power because they thought that the concentrated power of the federal government was going to infringe on their specific rights. And they supported a protection of individual rights. This primarily consisted of farmers and shopkeepers, those individuals who wanted to have operate in this state system and didn't want to have restrictions or implementations of things from the federal government. Now, we'll talk about why anti-federalism ultimately failed, but it was largely because of this focus on the support and the protection of individual rights. Once Federalists agreed to have an implementation of a Bill of Rights in the Constitution, the support for the Anti-Federalists largely dropped off. Now, the questions that they argued about were the system of government, the idea of whether states or the federal government had more power in these systems. And what we saw early in the American system is the legislature and the states had a larger amount of freedom in this federal government system. It was really following the New Deal, following the 1930s, following the Great Depression, that you started to see a larger piece of attention paid to the federal government system and less attention paid to state government systems. They also focus on the idea of the location of power. In the initial system, you had a capital in Philadelphia, capital in New York, and this was seen as antagonistic to the desires of the people in the South, the people in Georgia, the people in North and South Carolina, the people in Virginia. And so the location of power was particularly up in the air between Federalists and Anti-Federalists, and how those rights would be protected. The Federalists argue that not listing the powers was critical because it didn't limit them. The fear was if they listed them, then it would limit them. However, the Anti-Federalists are saying that if you don't list at least some of them, then you're not going to have any at all. And so when it comes to Federalists versus Anti-Federalists, the questions were about representation. What was the true picture of America? And as it expands, the question also happens is what happens if the country gets too big? What can scale up? The Articles of Confederation didn't scale up very well. If you have a single vote for every state, and every state has to agree, when you have 50 states, nothing would ever get done. You also have a scaling up of population. As more people come in, as immigrant communities come in, as immigrants come in bringing cultural and ethnic values, as ethnic and cultural values change within the population already in the United States, how is that represented? How is that a true picture of America? Now, they argued in a very specific way, the Federalists and Anti-Federalists. They argued through a series of published papers, and this was a very common way to engage in discourse. You would write a letter, you'd write a letter to the editor, you'd write a pamphlet or something like that, and you distribute it and try to get as many people to read it as possible. And so the Federalists were generally much more organized. They were largely supported under the writings of the Federalist Papers. The Federalist Papers were basically a collection of papers all written under the pen name of Publius, which is like the people, the public. And this was a collection of 85 essays supporting and defending the Constitution of the United States. And basically saying, between 1787 and 1788, basically saying that the Constitution is the superior of these systems and it should be implemented. Alexander Hamilton wrote a vast majority of them, wrote 51 of those articles. James Madison wrote 29. John Jay wrote 5. But in those articles, it was laying out the groundwork for those issues that were taking place. The Constitution, defending it, and defending why it was necessary. On the other side, the Anti-Federalists also published essays, and they were criticizing executive power and the lack of individual protections. One of the most prominent of these writers was Mercy Otis Warren, who wrote under the pen name A Columbian Patriot. She was arguing against the lack of individual protections, which many of the individuals were focused on. Many of the Anti-Federalists were focused on. They also focused on the idea of tyranny. Tyranny is the idea of oppressive government that employs cruel and unjust use of power and authority. The Anti-Federalists feared the creation of an aristocracy of power, basically ruling families who would have the most say in the governmental process. And the question we have to ask ourselves is, who is in charge today? Because this is kind of what happened. You had John Adams and John Quincy Adams, father and son, serve as presidents. You have the Kennedy family, largely political family. The Bush family, largely political family. You have all of these individuals who have kind of gained public prominence and used that prominence to kind of work themselves into kind of an aristocracy of power, where you have political leaders largely from similar families. And this is one of the things the Anti-Federalists feared. They feared not having a government that was representative of the individuals living in those communities. So the Anti-Federalists also wanted a limited government. Limited government is a government whose powers are defined and limited by a constitution. And Anti-Federalists viewed the Constitution and a vast federal government as potential for abuse. And so both sides favored limiting the government, but they favored them in different ways. The Federalists favored limited government through federalism, this process of checks and checks and checks and checks, where the Anti-Federalists wanted to have limited government through a system of state superiority with limited federal intervention. And so the Anti-Federalists wanted to limit power, and the Federalists wanted to, back to where we were. The federal government wanted to limit improvisation. They wanted to limit the ability for people to kind of maneuver and bend the rules. So Federalists agreed that abuse of power was possible, and then therefore they offered to create a Bill of Rights. After the offer to create the Bill of Rights, you had a large reduction in Anti-Federalist sentiment. So in response, like I said, they implemented the Bill of Rights. The Bill of Rights was basically the first 10 amendments to the Constitution. And amendments to the Constitution were implemented in the Constitution itself. And so the first 10 amendments allowed for the ability to protect the rights of the individuals. We're going to go over those largely in a future lecture. But an amendment is basically just a change to a bill, law, or a constitution. And this allows for the Constitution to change to reflect the attitudes of America. And so when it comes to passing an amendment to the Constitution, you can pass amendments through a couple of different ways. First, you have two steps. The first part is either it has to pass through 2/3 of Congress or 2/3 of specially convened state conventions. This allows for, even if the federal government doesn't necessarily support an amendment. An amendment can be proposed by the states themselves, by the people. And then the second step is passage through 3/4 of state legislatures or 3/4 of state conventions. So essentially, there are 4 ways to pass an amendment. They can use either of step 1 and either of step 2. So you can essentially pass an amendment to the Constitution completely circumventing the federal and state governmental system. You can have a special state legislature or a special state convention and another special state convention to pass these amendments. You can also have, now that has never been used, but it is possible. The ways that have been used where it will pass through Congress and then pass through state legislatures, or pass through Congress and then pass through special state conventions. So you use either 2 of step 1 and either of step 2. Now, in order to repeal an amendment, you have to pass a new amendment. So, for example, in the case of prohibition, the 18th Amendment eliminated or basically banned the sale, consumption, and distribution of alcohol. The 21st Amendment repealed the 18th Amendment. It's almost like a blockchain, where a constitution is a blockchain of saying that, okay, this is transcribed, it stays here, we don't get rid of it, we just note later on that has to be eliminated. And so since 1789, over 11,000 amendments have been offered to Congress of the United States. So 27 were ratified and only 25 remain in effect. So the question is, what rises to the level of a constitutional amendment? Well, it has to deal with the structure. In the past, it has dealt with the structure of government, such as the 11th Amendment, which limits the jurisdiction of federal courts in state matters. It can deal with the protection of the rights of the people, such as the 13th Amendment, which abolished slavery, or it can reflect modern American values, such as the 18th or the 21st Amendment, dealing with prohibition, how prohibition was implemented and then repealed. Thousands of amendments are proposed every year, but it is a very, very, very high bar to have an amendment reach the level of importance to be added to the Constitution. Now, what's the Supreme Court's role in all of this? The Supreme Court has the power to set limits on interpretation. So, what arms do you have the right to bear? Can you put a Patriot missile system in your backyard? Well, no, you can't. Can I use speech in a way that will lead to the direct harm of an individual? No, I can't. So there are limits that the Supreme Court will set on these rights in order to ensure that the public tranquility is upheld. Does the Supreme Court, or does the Constitution itself, guarantee an explicit right to privacy? It does not. That right is generally extrapolated through amendments like the 14th Amendment, but a right to privacy is not guaranteed in the United States Constitution. And so as we see kind of the evolving digital space, will we see a right like that be added to the Constitution? It is possible, but maybe not. And then the courts have decided through several cases, like I said, that is derived from the 14th Amendment, and this continues debate over strict construction and the living Constitution. Strict construction is the idea that the words of the Constitution as they are, as meant by the time, or should the Constitution be interpreted as a living document that changes with the people, with the attitudes, ethics, morals, and things of the people. So that's kind of how the Supreme Court engages with all of this. Now, for the next lecture, make sure that you're continuing to read your chapter. Like I said, a lot of the terms we haven't really covered. You're going over a lot of information. There's also some in-depth readings in the actual chapter themselves. In your book, there is the Constitution laid out with annotations, basically information about the Constitution. I encourage you all to read that. So make sure that you are caught up on that information. But until then, I will see you guys in chapter 3.